unfair to raise technical ground to deny pension after almost 4 decades of service. Bombay High Court to state, asking the state to put its house in order to ensure that retired employees are not forced to knock at its doors for their legitimate dues. The Bombay High Court recently directed the Joint Director of Higher Education to release the pension to a Sudhir Murkute, who was 38 years, a librarian. The High Court was deeply pained. It said that the state was seeking to deny the petitioner Murkute, 62, his pension in his twilight years on grounds that his appointment was not in accordance with the provisions governing the Pune University. The HC on February 20 directed the state to release his pension within 3 months from date of receiving its order. Such a query ought to have been made about 4 decades ago before his appointment, not for after all departments approved his post pay and in 2020 certified his retirement too. He worked at SVKT College, Nashik. The High Court bench of Justices A.S. Chandurkar and Jitendra Jain in its judgment said, "We hope that the state would take appropriate steps in such type of cases to put their house in order so that if any procedure in the process of recruitment of a person has not been followed, then the same would be communicated immediately to that person on being appointed and not after availing his services till the date of his superannuation." The High Court said, "We have not been shown any reason why the state and the Higher Education Department never objected to his appointment in the last 4 decades. It would be unfair for the authorities to now deny him his retirement benefits," the bench ruled, citing previous orders wherein similar cases of appointments belatedly being questioned, it had allowed the pension claim. The trust that runs the college had submitted all the documents necessary for processing the pension proposal. The High Court noted and dubbed as illegal and bad in law the state's refusal to grant the pensionary benefits to Mukute now. His claim was justified also on principles of legitimate expectation, as various deductions towards retirement were made from his salary with no objections from any department all along the HC reasoned. The HC remarked that the Supreme Court had 4 decades ago swept under carpet the antiquated notion of pension being a bounty, a gratuitous payment depending upon the sweet will or grace of the employer, not claimable as a right. It was an apt case for intervention, the HC said, adding that it also falls within the wide expanse of the meaning given by the Supreme Court to Article 21, Right to Life of the Constitution of India. An employee on his retirement makes various plans to lead a decent life and discharge his moral and social duties towards his family based on the amount to be received on retirement. If such a claim is denied on a ground raised for the first time after 30-80 years of service, then certainly intervention of this court under Article 226 is warranted to prevent justice being done to the petitioner, the High Court held. The High Court said the thoughts of employees on their last day of work may be along the following lines: navigating the golden years of one's life ought to be a time of celebrating and relishing life's journey, being secure in the knowledge that decades of loyal and faithful service have been valued and rewarded through assured retirement benefits.